So let's review those protected classes. Number one, sex discrimination. It does prohibit the use of one sex in employment decisions. So you can't say, I'm only going to hire women for this job, or I'm only going to hire men for this job, unless it is a job-related issue. For example, if it's somebody to work in a women's dressing room to help women get dressed, we're not going to hire a man to do that. If it's, we can say, I won't hire women to work in a maximum security prison with maximally violent male criminals, and we can say we are going to protect women from this job, and that has been upheld in the courts. Most positions really don't require that kind of protection. Very little requires that. So it really is, unless it is absolutely a job necessity, we're not going to use sex to make that decision because it's non-job related. It doesn't matter. If women and men can both do the job equally, then women and men should both have equal access to be able to do that job. It does allow, if you have an example of discrimination based on sex, then you can get recovery of money, particularly if for women, in a situation where that has been used as a form of discrimination. And it covers all, employment decisions, and it includes training decisions and performance appraisal decisions and compensation decisions and termination decisions. So can somebody be illegally terminated, for sex? And the answer is based on one's sex. And the answer, of course, is no, unless there is ample evidence that it is for, it's employment at will. Sometimes that's the case. Often it's not, although they try to pretend that employment at will is the situation, and when in fact it is because of someone's sex. But that being said, Title VII also prohibits based on race and color. So what that means is categories of race, meaning black, white, Latino, or Hispanic, you may hear it called, Asian, Pacific Islanders, and Native Americans. These are protected classes. And if you are told, I won't hire you because you're black, I won't hire you because you're white, I won't hire you because your skin is brown, I won't hire you because you are Asian, that is a form of discrimination. And so racial harassment is a form of racial discrimination where we are calling people racial epithets in the workplace. I won't get into repeating them because they're not fun to repeat and they're not fun to hear. But I'm sure you've heard it all at some point or another where someone is calling somebody horrible stereotype names that really just violates the law because it is a form of harassment. You cannot restrict positions, as you might for men versus women. You cannot restrict positions due to race. That would violate the law. Certain positions, for men versus women, as I've already said, you might be able to get away with doing that, but you cannot do that based on race or skin color. There's no justifiable reason to say, well, this position is really only for white people. There's just no defensible argument for it. In terms of religion, again, we are required to give a reasonable accommodation to somebody who is talking about sincerely held religious beliefs and practices. And so if someone comes to us, the assumption is always, if someone comes to me and says, I'm Jewish and this is a Jewish holiday and I need to have the day off for my religious beliefs, we need to accommodate that. And I lived and worked in New York City for a large number of years, and it was sort of surprising to me at first, but not so really much anymore. When I worked there, I noticed all the people who were conservative Jews who wore yarmulkes, or the Hasidic Jews who wore the black suits and have the long beards and the hats. If you have not seen them, then I'm just trying to describe what they would look like. Um, they are very visually clear that they are Jewish, and they would be leaving work at noon on Friday, and that sort of surprised me. And then someone told me, well, it's because people who have very strict religious beliefs in the Jewish faith, they need to be home and ready to go for their Sabbath at sundown on a Friday, because their Sabbath goes from sundown Friday to sundown Saturday. And they go to synagogue on Saturday, but they are not allowed to work. They're not allowed to even sometimes turn on their ovens to cook their meals or to turn on lights in their house. They're not allowed to work, and many faiths take this to a very extreme interpretation. And this is not a judgment; it's simply a statement of fact. They take it to its extreme limit, and organizations have to accommodate that. And so what we found was people would work an extra hour Monday through Thursday. So instead of leaving at 5 o'clock, they would leave at 6. But on Fridays, they could leave and have a half day. And so they would leave at noon. They would be able to be home in enough time for their Sabbath, be ready to go to honor their faith tradition at home. It is important that it is a sincerely held belief. And unless it absolutely poses an undue hardship, and there are very narrow circumstances where something can be, an undue hardship. It usually is financial, or it usually is, I can't even think of any examples where it's it might be considered an undue hardship. You may not use religious practices as a form of discrimination. You can't tell someone because they are practicing their religion that they cannot, that they will no longer have their job. And a sincerely held belief has to be a practice that is fundamentally a sincere and important thing for you. Training our managers to understand this is really important. It's important for all of these categories, but religion seems to be the one that is least understood, and it allows for a lot more discrimination than there should be. So it is important that we honor the multitude of religious beliefs in this country. Not everybody is Christian, so we have to allow for our Jewish members and our Hindu members and our Sikh members to all, and Muslim, everyone, right, to have their own practices and to be able to do that. So actually, I can't think of an undue hardship. There is there was a legal case where a number of Muslim workers were being told that there was no private room for them to pray during work hours. The company was sort of willing to offer that to them, but they said, well, we just don't have a space for them. And they ended up praying in the public, under public eye, and then they became targets for harassment and religious discrimination because they were praying in public, and they felt that they were unsafe and that the organization should have done something else to make them safe. And while the argument could be that it was an undue hardship to have a dedicated room for this, that doesn't mean that they couldn't have found a private space somewhere to do that. And in fact, that's what the courts found, that they really needed to do something to protect them. So they tried to argue undue hardship, but in fact, it really wasn't an undue hardship to them. But if you really don't have the space, then we've got to at least find a way to make sure people's practices are being honored and that we're doing the best we can to not let them be targets and to make sure that they're not being discriminated against. And I think what really hurt that company was not as much that they didn't have a space for them, but more so that they didn't protect them from the harassment and the discrimination that occurred because the only option was for them to pray in the open. And so then that pushed them to have to figure out and be a little bit more creative to figure out a way to ensure people had a safe place to pray. We cannot discriminate based on national origin. For example, if someone was born in another country but they have the legal right to work in this country, we cannot discriminate against them. We cannot discriminate against people who have an accent. As long as they are fluent and they can speak English, even with an accent, we cannot discriminate against them based on that. we can't say, well, our customers won't want to work with somebody who has an accent. You can't really do that. Um, if you are married to somebody who is not born in the United States, that may have an accent, that was born in another country, we also cannot punish them or discriminate against them based on that either. Um, if someone is seeking to be a U.S. citizen, um, then that's great, and we want to support that. We do that with visas. We do that with sponsoring people for visas and sponsoring people for their green cards and things like that. That can be done. You cannot say, unless it is absolutely a national security interest, which means working for the government, you cannot say you must be a U.S. citizen to come work for our company, particularly if there's nothing about what you do that is related to national security. So if someone has legal paperwork to be able to work in the United States, you cannot require them to be U.S. citizens to do that job. There are a number of amendments to laws, and one example is this is the Pregnancy Discrimination Act, which basically amended Title VII to say people who are pregnant or have pregnancy-related complications cannot be fired because of that. And if you cover other forms of short-term disability and you have health insurance, it must cover pregnancy. You cannot treat people differently because they're pregnant. You can't deny them leave because they are pregnant. It might be unpaid leave, but you can't deny them leave, and you have to make sure that you are offering them a job when they return. You can't tell them, well, once you're pregnant, we won't let you come back, because that's not an option either. Um, you can't also assign them to a worse job or an inferior job that makes less money and has worse working conditions if they come back once they come back from their pregnancy. So people should be trained regardless of whether they're pregnant. They have to have reasonable schedules regardless of whether or not they're pregnant. Obviously, if there is a medical necessity for medically necessary reason, sorry, I had a hard time saying that, a medically necessary reason for them to need an adjusted schedule, obviously that would fall under having a doctor's order and having that doctor's order submitted to the organization to say basically you must accommodate somebody because of the need to have an adjusted schedule. They need to have a place to put their feet up. They need to have a place to rest. They need to, they have to work from home certain days a week, whatever it might be, whatever the accommodation would be, depending on the pregnancy-related issue. Pregnancy is not a piece of cake. Pregnancy can result in mortality for the mother, mortality for the baby. Mortality rate here in the United States is actually unusually high for a first world country, and it's disturbing when I see that. So it's not enough to say, well, women had got pregnant all along, and people have always had babies. Yes, and people have died from those pregnancies. And so when someone needs medical care and medical accommodation, like a short-term disability, we are obligated to protect them and to cover them for that. The Pregnant Workers Fairness Act, PWFA, says we need to provide a reasonable accommodation to employees because of pregnancy and childbirth. And so we have to make a reasonable accommodation. So it's not reasonable to deny someone maybe an adjusted schedule if they can't work a full 8 hours. Maybe they can work 6, and they can work at home on some days a week. As long as the work gets done, we can make a reasonable accommodation. There's ways to do this in a way that would be fair to everybody. Another law that's important to note is the Age Discrimination in Employment Act of 1967, which prohibits discrimination against workers who are 40 and older. This is one of the few laws where people under the age of 40 are not protected from age discrimination. If you're 20 years old and I say you're not old enough to do this job or you're too young to do this job, you're not protected. This is the only law of all the employment laws that the protected group, the the people 40 and older are the only group protected. Those that are under the age of 40 cannot claim age discrimination. I'm not saying that I think that's necessarily correct, because if you're saying just because someone's age they can't do a job, but they have all the skills, I find that egregious, and we should obviously be hiring somebody who is capable of doing a job. To just say because of age you cannot do a job is not really okay, unless they're underage, or not under 18, in which case then that's about safety for children and youth, and making sure they're not working jobs that are onerous or difficult for them to do, or unsafe for them to do because they're too young to manage it. But this law protects people from 40 or older to be treated differently because of their age. They cannot be forced to retire. There used to be a mandatory retirement age back in the 60s, and that was changed with this passage of the ADEA. So we can't force people to retire, and we cannot, if we eliminate somebody's position and say, oh, we're going to eliminate it, but they don't eliminate the position for people who are younger, that's a pretext, right? It's like, well, we're eliminating the position. Yeah, but you've got other people that you've transferred into other positions, and yet you've not, done that for this individual because they are over the age of 40. And so often we'll hear even organizations going, well, it's a financial decision. They make too much money, so we're letting them go, and we're hiring people who are cheaper to do it. That also, it would have to really prove financial hardship for the organization to demonstrate that this is truly for financial reasons. They can't just say, well, it's cheaper to hire somebody else. They would actually have to prove that they are having financial difficulties in order to be able to do that. That doesn't mean organizations aren't going to try it. They do, but they would have to demonstrate, obviously, once they're sued, that this was really a financial hardship, and these are the things that they did, and that they actually laid off people who are not younger, that were not 40 and older, and that people, younger or older, were both treated similarly. You cannot fire people close to retirement age, because that is considered, again, a violation of due process, and it opens up the door that says, well, why are you discriminating against them? Well, I'm gonna, I fired them or demoted them before they retired so they would get less money, or they wouldn't get their pension, whatever that might be. So there's a whole host of things that people do that are kind of icky around this, where they, you might be a week from your, retirement age, and then they fire you, so you're not eligible for your retirement anymore. And there's plenty of documented cases of that happening. The Americans with Disabilities Act of 1990 prohibits discrimination against individuals with disabilities who can otherwise perform the job with or without an accommodation. So, and it was amended in 2008, the ADAA. But basically, a disability is defined as any physical or mental impairment that affects a major life activity. Breathing, mental health, depression, right? These are all, they interfere with someone's ability to live their best life. So if someone can't see, if someone can't hear, if someone has a broken leg, or they're missing a limb, we can't discriminate against them based on that. We have to be clear, what are the essential functions of the job? Because this is at the core of the ADA, or the ADAA. People have to be able to perform the essential functions of the job, with or without an accommodation. And then there are things that can be marginal functions of the job, which is they're not the most important things that they do. And here, let me give you a great example of this. An individual was working as a file clerk, and their job was to take files, and to make sure all the files get returned to the filing drawers. And this is a big issue. There was a full room where there was rotating files where people could get access to client files. Like law firms do this, banks will do this as well, where the entire room is just built to make sure we have access to files. And so an individual with a back problem can easily file things in a file cabinet. That's not an issue, or a giant rotating file. because the file is rotated in front of you, you pull the material out that you need, you put your file back, you close the drawer, and the thing continues to rotate, and you do your thing that way. And this person hurt their back, and they said, I can't lift the boxes to put them in storage anymore. I need somebody to help me with that. Everything else I can do in my job. And the company said, well, we're not going to accommodate you because that's an essential function of the job. But in fact, it was really a marginal function of the job, because a clerk can help, a mailroom clerk can help and lift a file box into a shelf or into a closet, or to load it into a truck. That is not the essential part of their job. The essential part of their job is managing the files on a regular basis to ensure the people doing the work can get access to the files, and that the files are handled appropriately and privately and follow all the rules that the company wants. Putting a box on a shelf is not an essential function of the job. It's something that can easily be considered marginal and can be done by somebody else. So our job descriptions are really important here, because we need to make sure that the job descriptions reflect what is essential, what is the most important, and what is marginal, but we'd still like you to do. And if someone has a physical disability and they can't lift a box, if lifting a box is a very small proportion of their job, like less than 1%, right, for example, then it's not essential, and then we can have an accommodation where somebody else can do that for that individual while they are managing their injury or disability, whatever it might be. We have to give a reasonable accommodation as long as it doesn't provide an undue hardship. And undue hardship is going to vary from company to company, right? An undue hardship for a large company is going to be very different than an undue hardship for a very small company, because a large company can absorb the costs to accommodate people where the accommodations might cost some money, whereas a small business does not have that capability. So there is no hard and fast rule of what is an undue hardship. The case has to be made by the organization about why this is financially difficult for them and what it could do or would do for their profitability or their ability to make money or whatever that might be. One particular area that's getting growing attention is having an inclusive environment for people who are neurodiverse. And neurodiverse can be ADHD, it can be Asperger's, or anybody on the autism spectrum. There are people who have Tourette syndrome. There's a whole wide variety of neurodiverse diagnoses, and organizations are working hard to try to accommodate people who are not neurotypical, people who may have sensory issues or things like that. Sometimes it can be working from home. Sometimes it can be giving them flexible hours. Sometimes it can be giving them a quiet space or giving them a headphone so that they are not distracted by noises. There's a whole host of ways we can do this. I mean, the goal is about 15 to 20% of the population is neurodivergent, and we're losing good workers when we are not finding a way to accommodate some of the challenges that occur. We do a lot of this in higher ed, and those accommodations need to transfer over into the workplace as well.